That being said, I'm going to try my best throughout today to not waste any more of your time than is absolutely necessary. Now, the court system can be a little slow, and there's going to be times when I have to ask some foundational questions and things like that that might slow down the process a little. So for that, I apologize in advance, but I will try to keep everything as timely as possible here today. Juror number 1, Mr. Diffender. Yes. Says you are a insurance claims adjuster.
Yes.
When you are looking into claims, what type of evidence do you look for? Is that your job or what's your role?
I actually work in our corporate office with my insurance company, and I oversee files that field adjusters actually have to report out to us. Yeah.
So when you're reviewing a file for a claims assessment, are you trying to look at every single factor? Are you trying to hit the highlights? How do you go about doing your job?
Typically, we look at every single factor.
Very thorough, very in detail.
Yes.
Okay. Juror number 2, Mr. Waters, says you are a sales rep.
Yes.
I have my dad, mom, brother, pretty much everyone in my family except for me, unless you consider lawyer salesman too, which I'm sure some people do. Pretty much everyone does sales rep work in my family. Are you comfortable telling me where you work?
Yeah, I work for Perry Foods, and I'm out on Michigan State University campus.
Oh, okay. So you sell to the students mostly, or?
Yeah, students and staff and managers. And
when you interact with other people, when you're working at the food stations down there, how do you go about resolving disagreements, disputes?
kind of take both sides of it. I'm not just going to go in, this person's wrong, this person's right.
Oh, I think that's a good thing. Does anyone, please raise your hand if you disagree with juror numbers 2's answer there about looking for both sides and assessing it. Seeing no hands, sounds like we all agree with that. I think that's a good way to be. Ultimately, as I'll tell you again in my opening statement, but I'll briefly tell you now, my job is simply to present evidence to all of you. Your job is to decide guilty or not guilty. I'm not going to step on your turf. I hope you don't try and encroach on mine. That would be a little weird. But what I'm going to do is just present evidence to you today. Of course, I'm going to make some arguments. Of course, I'll make some objections and ask questions. But ultimately, my job is just to present evidence. I work on behalf of the people. I don't work on any particular person. And as far as I'm concerned, the people includes Miss Otis here today. So I want to make sure that we have a fair trial and all the evidence gets presented from both sides that can. Thank you, juror number 2. I'm going to move on for now. Juror number 3. Now, I don't want to pick on you with this question, but I do see where you work. Do you know some people in law enforcement?
Yeah, I do know some people in law enforcement. I work with law enforcement.
Right. So do you have, because of your job with the Michigan State Police, do you have any sort of bias in favor of law enforcement?
I don't have any bias
What about against?
or against. I mean, I'm there to actually execute. I'm not there to decide guilty or not. That's not my job.
So if I started bringing some cops in here to testify, as I just told you, Officer Kurtz and Officer Backery, is that going to sway you any one way or another, or are they just a normal person?
That's just a person that have a job that happen to be in that area, but no.
I think that's a good thing. Does anyone else, I'll open it up to the whole panel here. Does anyone else, please raise your hand if you do have anyone that works in law enforcement or bias in favor of law enforcement, anything like that? Please raise your hand if you do.
My father and uncle are, well, my father was law enforcement, my uncle is law enforcement, but I don't have any bias.
So you think, although your father and uncle are law enforcement, you could still be fair and
Yes.
impartial in deciding this case? You don't think that me putting a couple officers up here is going to change your mind at all? Okay, good. Juror number 3, thank you. I'll come back to you later. Juror number 4, it looks like you're a cosmetologist and a paint safety sitter.
Patient.
Patient, okay. Patient, I read that wrong. Apologize. Now, I know I've talked a lot about my family already. My mom does cosmetology. Always has, always will, I'm sure. When you are trying to get the palette right, trying to match the skin color perfect, how much time do you spend doing it? How much time and effort do you put into that, or do you just have a standardized routine you use every piece of the way?
I've been doing it for a long time, so it goes pretty quickly. I know what colors I have on the wall, and I look at what the client comes in wearing, what they are already comfortable with, and I can make a pretty quick decision. Or get a few choices out and then let the client decide from there.
Fair to say you kind of assess the person as a whole,
Yes,
and you kind of maybe try to match it with their personality, with how they're dressed, things like that?
yes.
Juror number 5. I have here that you are self-employed.
That is correct.
Are you comfortable telling us what you are self-employed with?
Yes, I am a part-time graduate student working on my MBA, and I also am running a small photography, communications, media production, etc. firm.
Is that what the MBA is for?
Ultimately, I hope so, yes.
Okay, good. Well, congratulations to you. It sounds like you're a very creative person then, unless I'm mistaken with the photography.
Yes.
So when you are thinking of new ideas, things to put down, either to shoot or to put down on a canvas, however you do it, what goes through your mind? What are you trying to look for?
Well, generally, when people come to me, they want to be represented well. They want to have a nice representation of their family or themselves. They want to be able to, oh dear, I apologize. Everyone to make sure their phones are off. I had turned that off. My apologies. And what I'd like to do with that is just make sure that people are well represented. They feel like they get what they came for. They have a nice portrait they can put on their wall, or if they are a company that their business is represented well, this is what we do. This is what we do for our clients. You know, come to our business. We'll put a new roof on your house. Here's the people behind it. Just try to give an accurate and positive representation of individuals who come to us for that service.
Sounds like you're very detailed and thorough from my
I
assessment.
would certainly hope so.
Okay, good. Juror, thank you for that. Juror number 6. I have on my sheet here that you work in guest services. Are you comfortable telling us where or what you do?
I work at Powder Park too.
Oh, you work at the zoo. Oh, that's awesome. I love Powder Park Zoos. Tell all the animals I said hello. When you are dealing with customers at the front, I guess maybe guests is what you would refer to them as at the park. How do you go about, let's say an angry guest comes up to you complaining about their ticket. What do you do?
Well, I mostly deal with the concessions.
Okay, so they come up complaining about their lemonade. Now what?
Give them the option. Do you want me to leak it? Do you want to refund?
So it sounds you like to have options to choose from.
Yeah.
You don't like to just give somebody the story and call it a day. Juror number 7, juror number 6, thank you. Juror number 7, I have that you are a therapeutic activities assistant on my sheet. Are you comfortable telling us what you do?
Yeah.
What do you do?
Basically it's like I work at a nursing home and like we'll try to like get the residents to engage in stuff like bingo, stuff like that, get out of their room.
Okay, so you're the one that's making sure my grandma's having fun.
Yeah, that's it.
So when you are trying, I could imagine, especially from some of the stories I hear from my grandma about how her house is, I would imagine there's probably some disputes, maybe over bingo.
Yeah, usually we just try to diffuse it and separate.
How do you go about trying to diffuse it?
Try to make both parties happy and kind of see where they're coming from, what their frustrations are, and then kind of soothe them.
Now, you brought up something there I'd like to touch on, not to pick on you at all. You said that you like to try to keep them separate. Do you
Like
think
if
it's
they're fighting?
Yeah, do you think it's important to maybe separate when a fight happens before things escalate or turn physical?
That's usually what we try to do. We try to stop it before it gets physical.
Does anyone here disagree with juror number 7 that you should try to separate from a fight before it goes physical? Please raise your hand if you disagree. Seeing no hands. Please raise your hand if you feel that your friend is going to fight someone, you should join in too. Okay, no judgment, nothing like that. Please raise your hand if you think that's an okay thing to do. Seeing no hands. Now, before I get off this original topic about bias, I know I touched on law enforcement and all that. if anyone has any sort of biases or anything that you think would prevent you from fairly deciding this case, no matter who's involved in it, please raise your hand. Seeing no hands raised. Does anyone, please raise your hand, ever been involved in the criminal justice system? Seeing no hands raised. How about, do you know someone who's been involved in the criminal justice system? It's okay to raise hands. Please raise your hand if you have. Juror number 3, juror number 5. I know I'm hearing some hands back here. Gotcha. Okay, so juror number 3, juror number 5, juror number 3. Without getting into too much detail, because I know that could be personal, the prior experience that you've had, or that the person you know has had with the criminal justice system, are you willing to leave that at the door and decide this case on its merits? Do you think in any way that experience the person you know had has affected you or biased you in deciding this case? Juror number 5, same questions. Do you think that the person you know who's had an interaction with the criminal justice system, are you willing to leave that at the door?
I believe in the particular case, I was indirectly involved in justice was served. And I don't believe it will have a direct impact.
So you think you'd be able to stay unbiased and fair and impartial throughout this trial, even though you've had a prior experience?
Yes.
Okay. Now, as you've heard the judge read to you already, the complaint here, we're here for 1 count of assault and battery. A lot of people think about this about fighting. A lot of people think of it in a lot of different ways. So under the law, me spitting at you could be an assault. If that spit then hits you, now we've got a battery. Do we understand the difference there? Please raise your hand if anyone's confused. So an assault is something that can happen that puts someone in a reasonable apprehension of fear. You don't actually have to make contact. So if I swing and miss, it's an assault. Okay. Who here agrees? Please raise your hand, or how about I'll phrase it this way so we can get a little contrary. Who here disagrees that if you swing and miss, that's an assault? Disagree. Nobody disagrees with that. So we're all cool with the concept of if someone throws a punch at you, even if they miss, too bad, so sad, that's still an assault. We all in agreement with that? Please nod your head. They say more heads now. Okay. Now, we've got a standard here today that I have to prove to you this charge by. Okay, so it's just the 1 count of assault battery. Judge Simmons is very good at, and more than adept to read the law to you. It is her law. She is going to give you the law as it is instructed. So I'm not going to step on her toes and start reading the law other than what is exactly in the jury instructions in my open. Other than that, I'll let the judge handle a lot of that. Okay. So our standard is beyond a reasonable doubt. Sometimes this is a concept that's a little tricky to people. Admittedly, I was on the phone with my girlfriend last night trying to explain it to her, and I realized exactly how tricky it was after about 2 minutes of not being able to do it. So I'm going to try to keep it this way. Please raise your hand if you think I need to prove this case to you today by 100% certain. Seeing no hands raised, it sounds like we already understand the concept of reasonable doubt. So what I don't have to prove to you today is that beyond any possible doubt, this happened. My standard is not any possible doubt. My standard is not any doubt. My standard is not no doubts. My standard is beyond a reasonable doubt. You all seem like reasonable people, so I'm not going to step on anyone's toes with what they think is reasonable or not on what creates a doubt. The way I've heard it put in the past is that if there is something that causes you to hesitate to act in convicting, then that could be a reasonable doubt. So try to think of that concept throughout this trial. I hope that, please raise your hand if you think, or now I'll just put it this way. I think we all seem to understand that nothing in life is 100% certainty. So all I ask is that you don't hold me to 100% certainty, you just hold me to my burden, which is beyond a reasonable doubt. Okay? If you have a reasonable doubt, don't convict somebody just because I said so. Reasonable doubt is your standard, and I want you as jurors to maintain and uphold your position as in the law, because I think it's very important. All right. Now, covered a lot of the general stuff. I'll get a little more into the nitty gritty. And this will be a few more questions. I'm gonna pick on people one at a time here. Don't think I'm leaving you out. I'll look at you if I think you're making eye contact with me, okay? Let's go juror number 6. Let's imagine you get a call from your friend. Okay, we're about to go in a fight. What do you do? That's it. You don't go with?
No.
Okay. Juror number 3, same question.
Are you calling me that?
I'm just looking around the room. I can go to someone else if you want. Oh, I see. You're saying to your friend, not to me. Okay, I thought we were off to a wrong foot here.
No. A friend would put
Your
me
friend
on.
knows that you're not the one to
No,
call.
no.
Okay.
Don't put me-
Juror number 4. What do you think?
I would try and talk them out of it, and cooler heads prevail, and Farmer has a way of working those things up, they don't need to make things worse.
Juror number 1.
Yeah, I would ask some questions, try to figure out what's going on and why. I'd
2.
I'd also try to talk them out, and if they decide to go through with it, good luck.
Number 5.
I would attempt to intervene if I could,
What do you mean by attempt to intervene? Physically, verbally? How would you
try to diffuse.
try to diffuse,
Yeah.
not escalate?
Correct.
Juror number 7.
Same thing, I'd probably just try to diffuse it, make sure that they're all right. Make sure that, you know,
Fights at the bingo hall can get pretty tough, so good luck to you, sir.
right.
So if you hear that this case today involves some sort of underlying beef, ongoing dispute, and let's say both people were talking smack, okay? Please raise your hand if you would focus solely on that underlying beef in deciding this case. Seeing no hands raised. Please raise your hand if you would focus on the evidence and everything that was presented to you today and just completely ignore that whole underlying. Please raise your hand. Okay, I'm seeing no hands raised again. Now, how about this one? What if you're gonna do a mix of both? And you're probably gonna consider a little bit of how we got here versus what actually happened. Please raise your hand if you would probably consider both. Seeing everyone but juror numbers 3 and 4 or 5's hands raised. Juror number 3 look confused. Yes.
Yeah, because when you said,
Yeah.
the latter part, repeat what you said.
So we've got 3 options here, basically. You will hear allegations today that there was some ongoing beef and ongoing dispute. My question is, would you focus just on that beef and get distracted by it? Would you focus solely on what happened that night, or would you consider both?
To the vote.
Both.
Give it
Okay.
to-
Juror number 5, does that change your mind too?
I would, well, obviously, we want to know how we got to the point that we're at.
So you would,
Yes, I would appropriately consider both factors.
fair enough. Now, as I've said, you're going to hear that both parties here were talking some junk to each other on social media. Is anyone going to hold that against the victim in today's case, Kiana Smith, if you hear that she was talking junk on social media? Please raise your hand if you would. Seeing no hands raised. Going off of that point, juror number 2, do you agree or disagree that someone can say pretty much whatever they want as long as it turns physical? Or as long as it doesn't turn physical, excuse me.
I think people should say what they want to say, but to an extent, not if it will be physical, like freedom of speech is a thing, but like if you act on that, I think that's something to be done.
Let's say you go out to a bar with your buddies, right? Not saying you would do that, of course, but let's say hypothetically, you go out to a bar with your buddies. Somebody across the bar starts talking some junk, whatever, and your friend starts yelling at him back, saying stuff back, but nothing physical is happening. How would you feel about that?
I feel kind of weird as a third party, just like that's my friend, but I will also be like, let's just leave this sign worth it to sit there and just listen to it.
Juror number 4, what do you think?
I don't pay attention to people saying nasty things. I would either get up and leave or just ignore them. If my friend was kept it up, then I would tell them either you need to ignore it or you're on your own, because I'm not gonna be in the middle of this.
Your number 7, what do you think?
Could you repeat the question? I'm sorry.
So let's say you're hypothetically out at a bar, somebody starts talking junk to one of your friend starts talking
Oh,
back.
I would
What
just
would
try
you
to,
think?
I would just try to separate them, let them know, like, you're probably not gonna run in that person again.
Now, not that I am accusing anyone on this jury, because you're all amazing people of ever doing this before in your lives. But let's say that person that was talking junk back was you. Juror number 1, is that something you would do in a heated, potentially physical situation? Would you start yelling or screaming or saying things back?
Probably.
Juror number 2?
No.
Juror number 3? Juror number
No.
4? 5?
No.
6? Verbally?
No.
Just because we have a court reporter typing everything, so that's the only reason I asked. Juror number 7? Now, let's say that it's all over social media. You're not face to face. Does that change anyone's mind about that? Please raise your hand if it does. Seeing no hands raised. All right, stop it, done, de-escalate. Is that about right? Seeing all heads nod. Your Honor, at this time, I have no further questions.
Yeah. Good morning, everyone. Once again, my name is Luke Goodrich, and I'm here to represent Ms. Otis in this matter. The prosecutor briefly touched on this, but I'd just like to start with reasonable doubt. We're just going to randomly move through some people here. Juror 6, what does reasonable doubt mean to you?
That there's not solid evidence because you know the decision if that person is guilty or not.
And juror 1, what would you describe reasonable doubt as?
Reasonable doubt that there's a possibility that facts that presented may not be 100% accurate.
So if we're talking about, does the prosecutor have to prove that some aliens landed and didn't do it? No, he doesn't have to prove that clear. That's, there's always some crazy scenario you can come up with, correct? But beyond a reasonable doubt, it's still a high burden to achieve, correct? Juror number 7, would you agree with that, or is that a yes?
Yeah.
And juror number 3, if you get to the end of this trial and you get sent to the back to decide this case, and you just say, you know what, I do have some reasonable doubt here, but you're the only one. Do you think that you could stand on your own and keep to your convictions, even if other people disagree with you regarding reasonable doubt? Juror 5, do you think you could do that?
Yes.
Juror 4?
Yes.
Is there anybody here who thinks that, look, I'm not going to be the one person to stand up against the group? No? Okay. One thing that we've also talked about is the burden of proof in this matter. And as Mr. Markarian stated, it is his burden to prove beyond a reasonable doubt that Ms. Otis committed the offense that is alleged here. If Judge Simmons sent you to the back right now to decide this case, based on the evidence that you have heard, which is none, juror number 7, what would your verdict have to be?
We wouldn't have any evidence yet, so I wouldn't have one.
Well, would anybody disagree with that? Well, juror number 7, wouldn't you have to be not guilty if there's no evidence presented?
Yeah, if there's no evidence to prove you guilty, then you're innocent.
Right. So at that point, then you would have to find her not guilty if the prosecutor chose to present no evidence in this case?
I'll say yes.
Yeah, sorry.
See, I have a court recorder here, so she has to take down all the answers, so they must be verbal, okay?
Sorry.
No problem.
Okay, has anyone ever heard of a situation in their lives where somebody made a false statement to the police? Did anybody raise their hand? Juror 5, I see you nodding your head, yes. What type of evidence would you look for to determine whether or not that was factual or not?
If there was anything that could be reasonably, anyone can come to a cop and say, I saw this person doing this, but is there video? Was there a witness? Was there some other details that's more than just hearsay, is what I would want to see.
Okay, has anybody else come across this issue in their lives? No? Okay, well, one other thing that you'll see is, as the court has already stated, the prosecution will present their case first. They're going to call their witnesses, and then the defense will choose to, call witnesses, we'll have that decision at that time. Is juror number 2, are you willing to wait until you hear from all of the witnesses in this case and keep an open mind before you reach any conclusions in this matter?
Yes.
Juror number 6, do you think you could wait until you hear from every witness and not make up an early decision in this case? Would anybody think that they have a problem maybe hearing the first witness and reaching a conclusion? Okay, nobody's, I'll take that as a no from the group. I haven't heard any yeses. Okay, is there anyone here that feels that there's any reason that they might not be a fair and impartial jury for this particular type of a case? Because sometimes we have life experiences where you have a real bias on one area, but you might be a perfect juror on another. Is there anyone here that feels they might not be a fair and impartial jury for an assault and battery type of case? Juror 4, what are your thoughts?
I think I can be fair.
Juror 1, do you feel that you could be fair and impartial in this case?
Yes, I do.
Your Honor, we have no further questions at this time.
Okay, Mr. Montgomery, any challenges for cause?
None for cause, Your Honor.
Cause.
None for cause, Your Honor.
Entered.
Yes, Your Honor, the people would like to thank and excuse juror number 5.
Thank you, juror number 5, you may be excused. Any further pre-emptory at this time, Mr. McCray?
Not at this time, Your Honor.
Okay, and Mr. Goodrich.
Your Honor, the defense will thank and excuse juror number 6 at this time.
Thank you, juror number 6, you may be excused.
Edit.
Any other pre-emptory at this time?
Your Honor, I did have one question for the court, procedurally. If we pass at this time, are we allowed to come back to that person later if something changes our mind down the road?
I'll allow you to do that.
Okay, all right, thank you. No other, none at this time, Your Honor.
Thank you. You two may be excused. Thank you for your service. I'm gonna replace juror number 5 with Rebecca Snyder. Juror number 6 is gonna be Ernest Thomas. How you proceed?
Thank you, Your Honor. Jurors number 5 and 6, welcome. Juror number 5, I'll start with you. Is there anything about the prior questions that we both asked that you think the court should know about or that you wanted to put in?
So, no.
Juror number 6, how about you?
No.
Anything about the prior questions you think anybody should know? Juror number 5. I do not have on my sheet. Are you unemployed currently?
I'm disability.
Okay, okay. Well, I don't want to get too much into that personal situation there. Does your interaction with the people at disability, who I have heard some mixed reviews about, does that in any way bias you or put you against the criminal justice system, court system, anything like that? Well, I'm assuming that, and perhaps I'm wrong, I'm assuming you worked before this?
Yes.
What'd you do?
I was a medical receptionist.
Medical receptionist, okay, so are we talking billing, are we talking coding? What are we talking?
I was, when patients came in, I checked them in to be seen, checked them out when they were done, scheduled appointments, answered phones, faxing back and forth.
So let's imagine angry customer comes up, mad about their appointment getting scheduled or whatever. How do you handle that?
That was actually a good thing.
I would imagine so.
So, most of the time it was pretty easy. Most people, you know, took the explanation even though they didn't like it and realized it wouldn't. But there was times that there was people that didn't want to listen for anything, and most of the time the manager ended up stepping in if they're not choosing.
Now, what if you had a disagreement with your coworkers or your manager? How would you resolve that amongst coworkers?
I think if it was necessary, if it was, I would go to the manager, you know, work out the problem between the coworker and myself. The problem was with the manager, I would try to talk to them about it, and again, depends on what the problem. If it was severe enough, I didn't feel comfortable with them, I would go to their supervisor.
Let's say your friend calls you saying they want to go get in a fight. What do you do?
Try to talk them out of it.
Now, I noticed your mobility aid there. Are you gonna be okay with sitting through testimony, maybe an hour or two at times, things like that?
For an hour or two, yeah, it was much longer than that.
I'm sure we can provide you breaks throughout as necessary, as Judge already said, and I will add to, we will all need breaks too, I'm sure, so. Juror number 6, and juror number 5, thank you. Juror number 6, it says on my sheet here, you are retired. Are you comfortable sharing with us what you did before you retired?
Oh, I work for General Motors.
Okay, factory man?
Yeah.
Assembly line?
Yes, sir.
Which part?
Um,
Okay, got it. Okay, so when things are coming down the line, are you fine checking it? Are you looking through every hole, every nitty gritty, or are you just kind of doing your job and keeping it going? It's okay to say whichever. I would probably do the second one if that makes you feel any better about saying it. There's no way I'm checking every screw on that thing.
well, I would check everything and see, you know, if it's everything is tightened out and everything should be like it should be.
So you're a better man than me. That's fine. I've been there before. Now, when I talk about, or when we talk about the concept of beyond a reasonable doubt, are you going to be every single screw, every single hole, every single piece of fabric on that door, or whatever it is that's on the line? Are you looking through every single hole, or are you doing a big scan over, looking at all the important parts and calling it a day?
I'll probably look at the whole big picture and see if I see anything loose that need to be.
If you didn't see anything loose, everything was good, send it on its way.
Send it on its way.
Juror number 6, your friend calls you, says they're about to go get in a fight. What do you do?
Try to talk about it. Try to see if
Somebody starts coming at you. How are you gonna respond?
I'll probably try to do the same thing, try to see if I can calm them down and find out what the problem is.
They just keep on and keep on and keep on texting you, they're calling you, they're texting you, they're calling you, they're whatever. What do you do then?
Then I might have to make a decision to call the police.
Does anyone disagree that calling the police in that type of a situation might be a good idea? Please raise your hand if you do. Somebody raised. Your Honor, I have no further questions this time.
Yeah. Juror number 5, you stated before that you'd have issues in your job where people would come in angry and stuff like that. Did your manager or supervisor kind of show up behind you, kind of essentially for support at times?
Usually, I mean, the manager's office was close enough to the front end, they could hear, we wouldn't have to go to it. And so they would come out on their own. and they would kind of stand to the side where they weren't necessarily seen by the patient until the patient just, you know, there wasn't any working with them on my behalf, then they would come around. And
Okay, so
talk
they
to
would,
me.
they wouldn't necessarily go out and push the way through, but they would be there if you needed them, essentially.
Right, right.
Have you ever had a situation over the course of life, I guess, where a friend of yours was getting themselves in trouble?
I'm sure I have. I can't think of one right now, but at my age, it'd be weird not to.
Have you ever felt like you need to do something to prevent them from getting themselves hurt?
I've had situations where, you know, as he asked what I would do, where I've had to try and talk them out of and calm them down and remind them of what the consequences of doing that, you know, would be, and that type of thing.
Okay. And if you were the, I said, the only juror in this panel who felt that you had reasonable doubt regarding guilt in this matter, do you think that you could be one voice who kind of stood alone against everyone else?
Yes.
And would you hold it against my client if she chose not to testify in this case?
No.
Juror number 6, would you hold it against my client if she chose not to testify in this case?
No.
And would you agree that it is the prosecutor's burden in this case to prove her guilt beyond a reasonable doubt?
Yes, sir.
And similarly to what I asked juror number 5, have you ever been in a situation where you were concerned for your friend's safety based on some dispute or whatever they were getting into?
Yes.
And have you ever taken steps to try to keep them safe?
Yes, I used to talk them out of it. It's possible.
Okay. And was it possible for you to be supportive of your friend without getting directly involved yourself?
Yes.
Juror 5, would you agree with that?
Yes.
No further questions, Your Honor.
Challenges for cause.
No, Your Honor, none for cause.
None from cross and defense. Your Honor.
Any pre-emptory?
No, Your Honor, the people are satisfied with the jury.
Your Honor, the defense is satisfied as well.
Ladies and gentlemen, we have a jury. For the remaining of you all who did not make it into the jury box today, I thank you for appearing today and for being timely and attentive. There are further instructions that you'll get from our deputy court administrator as to your response to service or potential jury service later this week. But thank you again for appearing today. All rise for them to be excused. Thank you. Okay, and they have some- you can be seated. It's actually 12:02. I'm going to just go over some procedural instructions. And then I'm going to give you all a break for lunch. Mr. Margery?
Yes, Your Honor, my first witness, Officer Kurtz, I expect him to be a very short one. He does have, I think, a 1:30 cutoff, pretty strict, so I didn't know.
How do you get subpoenaed for trial and you have a strict 1:30 cutoff? It sometimes don't even get a jury and panel till then.
Yes, sir. Yes, sir. I'll-
Let's see. And the issue with doing that is downtown lunch spots close at 2 o'clock. Then the jury won't have a place to go to lunch. I don't know what the officer's cutoff is for.
He wasn't very clear with me either, Your Honor. I'm fine with keeping it going as we are.
Oh, sounds good. Okay. Okay, ladies and gentlemen, again, if you can face the screen, have some procedural instructions. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Can each of you stand and raise your right hand? Thank you. Do each of you solemnly swear or affirm in the action now before the court that you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instruction of the court? If you do so, please signify by saying I do.
I do.
Thank you. You can have a seat. You will get a copy of my instructions that I'm going to read to you, but you won't get them until the conclusion of the trial before it's time for you to deliberate. You'll be able to refer to them then. Since no one can predict the course of the trial, the instructions may change at the end of the trial. At the close of the trial, again, I'll provide you a copy of my final instruction for you to use during your deliberations. Now I will explain some of the legal principles you will need to know in the procedure we will follow in this trial. First, the elements of assault and battery. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Kiana Smith. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Kiana Smith's will. It does not matter whether the touching caused an injury. Second, the defendant intended either to commit a battery upon Kiana Smith or make Kiana Smith reasonably fear an immediate battery. A definition of force and violence as used in these instructions: force and violence means any use of physical force against another person as to harm or embarrass him or her. For a battery to occur, this is the definition of a touching. The touching must have been intended by the defendant, that is not accidental, and it must have been against Kiana Smith's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or, this is inaccurate, on or about, should be, we'll go back, July 26, 2024 at 3867 Wilson Avenue. In the city of Lansing, Ingham County, state of Michigan. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin, ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that might assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the case. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. You would raise your hand, write the question down, pass it to my court officer, and do not show it to any other of the jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater testimony or weight to testimony merely because it was given in response or an answer to a question submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand. That should say immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and that you are not allowed to discuss the case. If they continue, leave and report the incident to my court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. Again, the example is witnesses must swear to tell the truth and lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards. It could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not research any aspect of this case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, and magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated these instructions, please report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. As you can see, I have chosen a jury of 7. After you have heard all the evidence and my instruction, I will draw lots, which is names, to decide which one of you will be dismissed to form a jury of 6. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should take all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict, and your verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should only do so after listening to and considering the opinions of the other jurors who may have different backgrounds or perspectives from yours. You can proceed to your opening statement.
Thank you, Your Honor. Members of the jury, now you are officially sat, you are our panel, you are the ones that are going to decide this case. So a lot of the reason why I asked you in jury selection about what you would do if a friend called you saying they were going to a fight, because that's why we're here. If your friend jumped off a bridge, would you do it too? That's something that my mom told me, God knows how many times growing up. It's a lesson that I think we're all familiar with. And it's one that I think most of us would say, well, no, hold on. Kind of a bridge, how high, how far, what kind of rocks, all that. We're not just gonna do something because our friends did it. And if you did, you got hurt jumping off that bridge, there might be a certain portion of us in this room that go, hey, you know what you signed up for. Your friend jumped off a bridge and you followed. What happens after is your own fault. Members of the jury, that's kind of what I'm going to ask you to decide and focus on in this case. As I touched on in jury selection, there was clearly an ongoing dispute on social media between our victim, Kiana Smith, another person named Nyquilla Powell, and this defendant, who's Nyquilla's friend, Jada Otis. What you will hear is that on the date of July 26th, 2024, there was an apartment complex located at 3867 Wilson Avenue, Lansing, Ingham County, Michigan. I say those things because as a precursor throughout this trial, you might hear me ask some weird questions about dates, locations, times, things like that. Those are all preliminary things I have to address. I will prove to you that date of July 26th, 2024. I will prove to you that location of 3867 Wilson Avenue in Lansing, Ingham County, Michigan. And what I will prove to you happened at that location, at that date and time, after midnight, was that this defendant, Jada Otis, went with a group of 3 of her friends, so 4 people in total, in one car, parked behind the victim who was talking some junk on social media. And then 4 of them proceeded to get out of their car, start pounding on her window. You will see the video. You'll hear things about, frankly, I'm going to get out in front of it. Our victim saying a lot of things that I wouldn't condone. A lot of things that I think we all agreed in jury selection we wouldn't have done ourselves. We wouldn't be trying to talk smack on social media knowing that somebody is potentially looking for us for a fight. We might try to de-escalate it. But not instigating a fight is not one of the elements that I have to prove here today. Members of the jury, what I have to prove is assault and battery pursuant to Michigan Criminal Jury Instruction 17.2. First, that the defendant committed a battery on Kiana Smith. A battery, as has been defined, as any forceful, violent, or offensive touching of the person or something closely connected to them. Specifically, what the evidence will prove in this case is that this defendant, Jada Otis, after there had already been banging on the window, after the victim had already backed her car out in an effort to block them because she was planning to call police, after all that, the defendant and her friend Nyquilla got back out the car, went up to the car door, somehow forced their way inside of what was once a locked car door, and while Nyquilla was hitting Kiana in the front seat, what you will hear, the evidence will prove, that this defendant, Jada, also decided to get her licks in. She opened up the back door, and she started throwing punches too. That's why we're here. Don't know if that sounds oversimplified or not, members of the jury, but frankly, that's why we're here. Assault and battery is a forceful, violent, or offensive touching, and this defendant, as the evidence will prove and you will hear, did open a car door and punch on the victim. Assault and battery. Second, I have to prove that the defendant intended either to commit a battery upon Kiana or to make Kiana reasonably fear an immediate battery. Members of the jury, once you hear the testimony, you see the evidence, I think that element will more or less speak for itself. I want to be clear. You will hear that Kiana Smith did not consent to any of this. And the reason why that matters is because you will hear, I suspect, arguments and statements from the defendant herself to police, saying that this was all just some big mutual fight. You see, you'll hear from Officer Curtis first, or Officer Kurtz first. Officer Kurtz will explain that the defendant, after being Mirandized and following all the rights, gave a statement to police. The defendant's version of events is that this smack talk on social media was an invite for a mutual fight. When she had 4 people and the victim was there at her friend's house, but in a car alone by herself. So one of the questions I'm going to ask you to focus on throughout this trial, members of the jury, is it possible to have a mutual fight when it's 4-on-1? If the answer to that is no, then you're already headed down the path towards a guilty verdict. Now, we can't just stop there. You will hear from Officer Jamil Bakri. Officer Bakri will explain that he was the initial responder to the scene. He will describe what the scene looked like upon his arrival, who he spoke to, and how he determined who was assaulted and who did the assault. Finally, you'll hear from Kiana Smith. She's the victim in our case, and she will take that stand and testify you and tell to you in her own words exactly what happened. I anticipate Kiana is not going to hide away from this ongoing dispute, or the fact that she verbally played a role in, or the fact that she could have maybe, like we all talked about in jury selection, stopped, de-escalated, and backed up. What is not right, and what makes this criminal, is when, although she didn't stop, back down, and de-escalate, these girls showed up with 4 people in a car to jump her. That's where we get criminal. And when Jada Otis puts her hands on her, as we will prove she did, that's how we get to assault and battery. In fact, as we agreed, I don't even have to prove she actually hit them. That's what we talked about during assault. Members of the jury, you'll see 2 videos. One is recorded from the victim's phone. It'll be on a body-worn camera because she was showing it to officers that night. It was her Facebook Live video. As I told you, I'm not going to hide from any of this. I'm not going to try to dispel the fact that our victim did some things that I wouldn't condone here. But what she did was not criminal. And I'll play that video for you. You'll hear the stuff she was talking. And I'm sure we will all be shocked together that someone did that. But keep in mind her age, social media, and the environment that we live in when you watch that video. Because then, the video that was recorded by the defendant herself, who you will see in the first video, showed up wearing a ski mask with 3 of her friends. And then in the second video, she decided to record this all as it was happening, and you'll see that too. It's from the outside of the car, and the first one is from the inside. Finally, you'll hear Kiana Smith's phone call to 911. As the jury of the triers of fact here, it's your decision to decide, or your turn to decide what the facts are and are not. However, I would suggest to you to pay attention to that 911 call. I believe you can hear what I think is Kiana Smith being assaulted in real time on that 911. We've got videos from when she started talking until what I believe is the assault. Members of the jury, it's for those reasons that I would ask you to consider. Was this really a mutual fight? Was it a beef that escalated into something more? Or was it just an attempt to track down and hunt Kiana Smith the whole time? As she will tell you herself today, she was trying to avoid these girls. She was trying to get away from them. And they showed up with 4 people at her friend's apartment just to fight it. That's how we get assaulted. Thank you all. I can clearly see you're taking your job seriously. So with that, I'll stop.
Mr. Goodrich, did you want to give a statement now?
Yes, Your Honor. Ladies and gentlemen of the jury, you will not be hearing the defense arguing that this was some type of mutual fight, because there was no fight. You will not only hear from a number of witnesses, but you will also watch videos of what occurs in the situation. Miss Otis is a passenger in a vehicle driven by Niquela Powell that arrives on scene. You'll hear, like I said, the background information of Miss Smith. Well, I think beginning, the whole story basically is going to start with this fact. Miss Powell is currently dating the father of Miss Smith's child. And that is the dispute between these two women. And it is a very hostile relationship between the two of those women. Miss Otis is a friend of Miss Powell. Miss Powell, while Miss Smith is doing, you'll hear how Miss Smith is doing Facebook Live from her car, calling out Miss Powell, challenging Miss Powell. Miss Powell, again, would I advise Miss Powell to go to that scene and try to get a fight going? No, I would not, but that is what Miss Powell did. Out of concern for her friend, Miss Otis and two of her other friends get in the car and go with her. Miss Otis, you will see, again, never engages in any type of fight. We have video to back this up. There is not, you'll hear how Miss Powell starts knocking on the window, asking her to come out of the vehicle. Why was she knocking on the window, telling her to come out? Because the doors were locked and the windows are up. There's no way to ever get in that vehicle. At some point, you'll see how Miss Otis, well, she's hanging out in the back, filming things. You'll be able to see that because we have the video that she was taking. So you'll be able to see where she is. At some point, they get in their car to leave. And then you'll hear how it was Miss Smith who backed her car up to prevent them from leaving and extended the situation further escalating the situation. But again, you'll hear how, again, it was Miss Powell who gets out and starts arguing further with Miss Smith. These two go back and forth over and over and over. Miss Otis never gets near the car. Well, when I say near, she gets toward the back of the car. She never goes inside that car. And after that first initial interaction, she never gets near the car again. She stays back by Miss Powell's car. She's either in the back seat of Miss Powell's car or standing right outside of the car, half in, half out of the car throughout for the remainder of the situation. Soon thereafter, the police arrive. When the police arrive, you'll hear them testify, oh yeah, but Miss Otis and the friends were all sitting in the car when we get there. You will not hear, you'll also hear how Miss Smith was, had a friend, was there driving her friend's vehicle. Her friend was in an apartment nearby. That's why they were at that location. Her friend shows up on scene. I don't know if you'll hear from that friend or not, but you're not going to hear her come in and say, oh yeah, I saw Miss Otis up near that car, because it didn't happen. You're going to see video evidence that Miss Otis was not at the car. You're going to hear from multiple witnesses that Miss Otis never went in that car. The only evidence you're going to hear that she was is from Miss Smith herself, backed up by zero evidence. And you'll hear how she embellished and lied to the police on multiple occasions to blow the situation up into something that it was not. So I believe that when you get a look at all the evidence in this case, you are going to have no problems concluding that the prosecutor has failed to prove beyond a reasonable doubt that she committed an assault and battery in this case. And I just want to make it clear, standing by a car is not an assault and battery. You actually have, do you have to strike a person? No, but you at least have to swing or put them in a fear of an immediate battery. Standing in the back and saying, well, I'm scared of a person, that is not an assault. And I don't believe that's what the prosecutor's arguing in this situation, but based on the evidence that you'll hear from numerous witnesses, that's exactly what Miss Otis was doing. And essentially Miss Otis's collateral damage to Miss Smith in this ongoing battle she has with Miss Powell, who is dating, like I said, the father of her child. And if it hurts Miss Otis along the way, she doesn't care as long as it hurts Miss Powell as well. So again, we're going to ask you to find a verdict of not guilty at the end of this trial. Thank you, Your
Call your first witness.
I believe I emailed the officers and sent them away because I thought we were taking a lunch break. I apologize.
Oh, okay, I thought someone had to cut off. Okay, we'll take a look.
They did, I've worked that out.
Okay, sounds good. Okay, so we are going to take a break. I think you all should have received a juror sticker. That sticker should be worn so that you're identified as a juror in the building. Again, remember the instruction that you're not to have any discussions with anyone connected to this case. And because you don't know who may be connected to this case, you need to be identified, but you also have to be really careful because you can inadvertently speak to someone that you shouldn't. If you find that there's been a violation you should report it immediately. And a violation could be very simple, as you were in the restroom, and someone spoke to you and you later realized it was a witness or a victim. You want to report it to make sure it's properly addressed, okay? There are some restaurants of the main strip, for those of you all who are not familiar with the downtown area. And then the jury room back here is only accessible to the jurors, so that room will be locked until you return if you want to leave anything in there. And then we will be back here. I'll give you until 1:45. All rise for the jury.
All right.